the power under entry 50. That's the crux of it.
Thank you. Yes, Mr. Datar.
I made a PowerPoint presentation, but before Mr. Daras Khambata concluded, there is a very important passage in the Joint Committee in 1933-34, which prepared the Government of India Act. And I just flagged that the original entry 23 of List 2 said that tax on mineral rights, they were no subject to limitation. And there was a general power given to the federal government. A member of the committee called Lord Percy, he flags the issue and says, if you give complete general power to the federal government and unlimited taxing power to the provinces, then the very regulatory power of the federal government will be in jeopardy. That is why then they put subject to mineral rights. I'll give that passage from Lord Percy, and the Solicitor General agrees. Yes, this is a very valid point, because unlimited taxing power can completely jeopardize the regulatory power of the federal government. Now, my lord, I'll come to my submission straight away. My lord, first of all, the taxing powers of the state. There are normal allocation of taxing powers. There are 12 taxing powers given to the union, entry 82 to 96, 92B, and 16 subject matters given to the state government. That is 46 to 62. It's now one less because entry tax is gone, octroi is gone.
And to the union, which was one?
Union 12 subject matters, and to the state 16. Now 15.
82
to 92B.
Yes.
And for the state governments, entry 46 to 62. Of course, now 55 is deleted after GST. But out of these 15 taxing powers,
54 is deleted.
Sorry, my lord.
The 54 is deleted.
55 is deleted. Entry tax.
Oh, 85. Yes, 55.
Because now it's one nation, one tax, so there's no
Right.
check post and all that. Now, my lord, out of these entries in the state list, 3 entries use the word subject to. Entry 54, the power to levy sales tax, is subject to 92A of list 1. Lord, I'll give a complete note, my lord, to save time. Entry 54 is subject to entry 92 of list 1, interstate sales. Entry 50 is subject to a law made by Parliament. And entry 57, motor vehicles, is subject to principles in entry 55 of list 3. So 3 taxing entries are subject to something. Now, the word subject to has been subject to a lot of interpretation, and a recent judgment by my Lord Justice Gawai and Justice Nagaratna in the case of Baharul Islam, Lordship will just make a note, 2023 SCC online. Page 79, 2023 SCC online, page 79. Para numbers 85 is the most important. Subject to means yields to. So a taxing power which uses the word subject to X must yield to X. Now take 50, Lord. I'll not get into entry 54. If I have time, I'll mention that. So 50 says subject to a law made by Parliament. So my submission is this taxing power is still a state power. There's no question about it. Because all the money goes to the state. All the money goes to the state. But it is subject to a law made by Parliament, meaning the taxing power of the state must yield to parliamentary legislation. And what has parliamentary legislation done, my lord? My lord, I am taking the plea in my slide number 2. My lord, I took the liberty of making a PowerPoint so it will save time. Lordship just sees slide number 2. I'm just going to refer to slide 2 and 4.
Page number?
Slide number 2, my lord.
Where did we get that?
I've made a PowerPoint presentation. I got hard copies if your lordship wants to save time. Lordship may just take the hard copy. I just got 10 minutes.
No, just one second. But written submissions volume?
No, I gave, Lord, what happened? I gave written submissions earlier.
PowerPoint.
In written volume 2 it is there. Volume 2 what page?
The PowerPoint is there?
Folder volume 2. There's a separate file.
Well, can you just take a hard copy, my lord? I've got 10 minutes.
Quality presentation is there.
Yes.
Very much there.
What page number, my lord? Your lordship has got slide 2, my lord. I'll just give a hard copy in case your lordships are finding it. Yes. Now please come to slide 2. Now I'm submitting what Parliament has done. Slide 2, lordship comes to limitations on taxing power. My My lord, my submission is, sorry. My submission is, all your lordships have got it, no? All my lords have got it. List. Yeah. My lord, can I pass on a hard copy in case it's
It's there in it.
yes. Now, my lord, I am submitting that when you say taxes on mineral rights, when a legislature has the competence to make a law relating to tax, it basically can decide on three components: the levy of tax, the assessment of tax, and the collection of tax. My humble submission is, what Parliament has done is, it has divided minerals into two parts: major minerals and minor minerals. On minor minerals, under 15, state can levy tax. In Tamil Nadu, they call royalty on major minerals. They call it seigniorage on minor minerals. But both are basically taxes or imposts. Now my submission is, why did Parliament do this? Parliament did it, in my humble submission, to impose financial guardrails or financial limitations in national interest. And I'll draw a parallel to sales tax. So the first submission is, Parliament has imposed limitations on major minerals. They have set out in second schedule what are the major minerals. They have specified how much you can tax, either so many rupees per ton or 5% ad valorem, 20% ad valorem. And then, my lord, allocation of taxing power, taxing revenues. Insofar as 9 is concerned, Parliament says entire thing goes to Consolidated Fund of State. Come to 9B. 9B, District Mineral Board, it says it will go to the district, doesn't go to the state. It goes to a trust to be used for the purpose of the district. So what Parliament has done is, this is how the taxing powers has been regulated by Parliament. So they make a law which imposes the levy, but the entire funds go to the state. And this is what I've said. Now, my lord, kindly come to slide 4. Please come to slide 4. I have drawn a map of Tamil Nadu. Lordship has got the map of Tamil Nadu.
Yes.
My lord, what I've done is, what is the Lordship kept asking the question, what is the interplay of 49.2 with entry 52? Now, I'm just making a suggestion for Lordship's kind consideration. Now, tax on land and buildings, land will be a genus and mineral lands will be a species, because not the entire state may not be a mineral. So what I'm submitting is, under the Mining Mineral Development Regulation Act, you have reconnaissance permit, you have this permit, and ultimately a mining lease is given for a period area not exceeding 10 square kilometers. It can be extended depending. So some mines can be 30 kilometers, 40 kilometers, etc. Now, I'm just suggesting to your lordship that whatever is the black dot represents the area for which a mining lease has been allotted. And who gives the mining lease? The state government with the approval of central government. You make an application to the state. And so my humble submission for lordship's consideration is, the black dot area is the entry 50 tax. Rest of the state is a 49 tax. And on the black dot area, they cannot be both a 49 tax and a 50 tax. That's the submission. Now, my lord, third point on why royalty is a tax. But I'm very clear, royalty is a tax. You can call it impost. That's not quibble on words. It is a tax. It's an impost. And why do I say it's a tax? On India Cements, where lordship sees, the opening page of India Cements is page 1155. And at 1156, my lord, Justice Nagaratna asked the question, what is this royalty? The opening paragraph of Justice Mukherjee's judgment says, India Cements is paying royalty at page 1156 under the Mineral Concession Rules 1960, which is under the 57 Act. And please see, what do they say? Royalty, limestone, government land, 75 per ton, subject to rebate. The schedule. Now, my submission is, what are the indicia for a tax? Typically speaking, because if you apply the Wambach test, royalty is not a tax, then what is it? Is it consideration? Is it rent? It fails because the indicia for a tax is, it is normally given at a particular rate. The word rebate, ad valorem, schedule, alteration, all these are factors which are very, very unique to a tax. Consideration under 2D contract is nomen juris. It relates to a contractual relationship. In D.K. Trivedi, Justice Madan said a mining lease is not an ordinary contract. So my humble submission is, royalty is a tax. That's the first submission. Secondly, the District Mineral Board is a percentage of the royalty. That is also a tax. And finally, my lord, I'll say why India Cements was wrong. Oh, sorry, why Kesaram was wrong. India Cements, what happened was the royalty was under these mineral concession rules, parliamentary levy, parliamentary rules. The Tamil Nadu government under section 115 and 116 of the Panchayats Act said the cess will be at 45% of the royalty. They said 45% of public revenue, and then they amended the explanation and said land revenue in public revenue includes royalty. Now, Kesaram says cess on royalty is a tax, but royalty is not a tax. In my humble submission, it's a logical fallacy because 99.99% of the cases in tax law, everybody who practices tax knows, cesses and surcharges are piggyback levies. They are always related to a mother levy. Education says 12.32% of the service tax. Higher education says 0.6% of income tax. So if the cess on service tax is a tax, then it's paradoxical to say that the mother levy is not a tax. And that's exactly what Kesaram does. They say, no, royalty is a tax is a typo, but cess on royalty is a tax. Now, if cess on royalty is a tax, by logic, my lord, the royalty has to be a tax. I'm putting the inverted paradox. And finally, my submission is royalty is also taxed because it satisfies all the four tests of Govindram Ganga Saran. Your lordship sees, I've given in the last slide. What are the four attributes of tax? I've given in slide number 8. Taxable event, person liable, rate of tax, value or measure. All these things are satisfied. And finally, not just 1 minute to say how Parliament subjects it to levy. Take sales tax, not just one, I'll conclude. Entry 54, till this Bengal immunity, lordship, now the full confusion in Bengal immunity, which state can levy tax, United Motors and Bengal immunity. Ultimately, the validation was upheld in MPV Sundaramaiah. After the 6th Amendment, they introduced 92A and said, what was an absolute power of the state was taken away and made subject to 92A. So what happens in 92A? Central sales tax. Central sales tax puts two limitations. It under section 14 makes declared goods, which include many of the minerals also. Otherwise, each state can levy whatever it wants.
Thank you, Mr. Datar.
I think I'm less than 10 minutes. But any yes.
See, not only you, others have also argued this. Money going back or the entire money is usurped by the state. Should that be the logic for?
Yes, I'm very grateful. But I'm just, my Lord Chief Justice also raised the point. You keep saying it's a tax on, it's a state tax. Just think for a moment. Just suppose Parliament tomorrow says, I will make the law and I will keep the entire money with me. That could be a serious challenge because you can't make it a state levy and the entire funds goes to the Consolidated Fund of India. Because the point is, why I'm saying
that
it's
is simple enough.
Huh.
But if we understand that state has a power to tax,
yes,
and if center says that no, I will impose the tax,
for major minerals.
but I'm giving you 1 minute.
For major
right,
minerals. Yes,
right.
yes, yes.
But I'm giving you the entire, let us say entire.
Yes.
Does that satisfy what is given to the state under list 2?
Lordship may not just take giving.
Despite the
Yes. Lordship may not just take giving. Entire assessment is by the state. Collection is by the state. Special courts are set up by the states. All the Parliament is doing is don't go haywire in a levy. Suppose they leave it to the state government. Then any state government can levy any tax. So what I'm submitting is the very fact that the entire money goes to the state itself shows that the state is not denuded of their taxing rights, taxing money. All happens, the ceiling limit is imposed. Like in sales tax, once you're a declared goods, you can't put more than 5%. Sorry.
56 interstate trade is
Exactly.
only by the central government.
Pardon me?
It's only by the parliament.
Yes,
Under
again, what happens is,
The
the-
power under Article 286
yes,
with regard to interstate.
interstate sales,
Only the parliament.
only when parliament can levy.
Only the machinery is by the state.
Yes, why I gave the analogy?
From the power to impose a tax.
No, why I gave the analogy is, after 6 years of independence, the state's absolute power became subject to limitations. Now, limitations can be in any way parliament wants. In sales tax, what did they did? They said not more than 5%, only single point levy. For minerals, they said, major minerals you can tax in the second schedule at these rates. So now suppose it is 8% ad valorem, it's an all India tax. Whether you find the coal in Bihar or you find the coal in Karnataka, it's an 8% tax.
So feeling the heat from behind?
Very much, my lord. My lord, unfortunately, I can't be pushed in front.
Thank you, Mr. Datar. Now, Mr. Datar, you have to tell us who is following now next.
Mr. Ghosh is following, and he wants to take 1 minute to.
Just a minute, I'll take. I'm going next subject to.
No, no, tomorrow.
90110,
My lord, at the de-tagging, I'll give the note tomorrow in my matter.
90110. I have only 3 points to make and I will not take more than 10 minutes. 3 issues have been troubling this honorable court. First,